to the living will. This is a declaration of living will. There are a great deal of misconceptions about the living will. Obviously, a lot of people confuse it with the regular will to dispose of your property when you pass away. A living will is a way to refuse certain kinds of treatment. A lot of people think that they can refuse whatever kind of treatment they want in a living will, but actually the living will is very specific, and it's specifically provided for in the Montana Code. And I'm going to go to that link. There are two kinds of living wills, and there are other code sections going along with the living will which provide, probably most importantly, among other things, that your treating physician or treating healthcare provider is required to follow your living will if it's properly executed according to the law. And if they're not willing to, then they have to transfer you to a provider that will follow your wishes in the living will. But the living will is actually very narrow in its application. It only comes up if three pretty specific requirements are met. One, the person has to be incapacitated. Just like I said with the healthcare power of attorney, if you're capable of making your own healthcare decisions, then you can decide right there whether you want life-sustaining treatment. So it will only come up if the patient is incapacitated. Secondly, it only comes up if the person has been diagnosed with an incurable condition by a doctor. And three, that incurable condition is going to result in their death in a relatively short period of time. Now, relatively short period of time is not specifically defined. It's typically considered to mean within a couple, 3 months at the maximum. So that's relatively short period of time. But the living will is only considered and followed if those three requirements are met. Incapacitated, diagnosed with an incurable condition, which is going to result in their death in a relatively short period of time. If that's true, a lot of people want to refuse what's called life-sustaining treatment. And on that note, I don't specifically recommend this document to my clients because I think it's a very personal decision. Some people want to refuse life-sustaining treatment. And by life-sustaining treatment, I mean treatment that is not going to address the condition. All it's doing is prolonging the dying process. It's not treating the condition or actually making you better. It's just drawing out the dying process. That fact, combined with the fact that a lot of life-sustaining treatments are extremely uncomfortable and can even cause injury, such as CPR or feeding tubes or breathing machines. A doctor could probably be more specific. But my point is that a lot of people don't want that kind of treatment because it's uncomfortable and painful, and it's not really helping them. It's not treating the condition. It's just keeping them alive. So a lot of people want to refuse that kind of treatment. Under those circumstances, a living will is the way to do it. There are two kinds of living wills in the Montana Code. One is the living will that I described, and one is the living will, a declaration of living will by appointment, and that's when you appoint an agent to make the decision to refuse life-sustaining treatment. In my opinion, if someone's going to, someone should make that decision on their own regarding life-sustaining treatment. It's literally a dire decision, and so that shouldn't be passed on to somebody else. But if they want to appoint somebody to make that decision regarding life-sustaining treatment, that provision is also in the law. Prior to processing the living will, I recommend reading the other parts of the Montana Code because it does provide rights of the terminally ill. It's called the Rights of the Terminally Ill Act. It provides rights and directions to physicians and healthcare facilities on what to do when they're presented with a living will. So it's definitely worth a read. The living will does not apply in emergency situations. It is not a do not resuscitate order. Previously, these kind of things were known as Comfort 1. And so if someone is having a heart attack either in the emergency room or at home and they require emergency treatment, the living will does not apply. It does not apply in emergency situations. In order to refuse life-sustaining treatment in an emergency situation, you have to get a physician's order. That's typically called a DNR, or do not resuscitate. It used to be called a Comfort 1. And now, the vast majority, if not all, facilities in Montana have switched over to the pulsed form. And I believe I have a link for